A very good day to all our listeners. UCS is back again with another informative episode. I am Shushmita, a corporate lawyer and a trainer at UCS. We have with us today Kaveri, my colleague, who is a corporate lawyer and a trainer at UCS too. In today's podcast, we are going to be talking about situations where there can be a conflict of interest when a case of sexual harassment is being handled by the Internal Complaints Committee in an organization. Hi Kaveri, how are you?
Hi Sushmita, I'm well. How are you?
I'm doing well, Kaveri, thank you. I have a question. When a case of sexual harassment is filed, and if one of the members of the IC is friendly with the complainant or the respondent, won't the attitude of the IC members be biased and favorable towards that person?
Sushmita, this is a very valid question that you have asked me. IC members from an organization generally know most of the colleagues who they are working with. And in some situations, they could be more friendlier with a few people, and it can turn out that such person who they are more friendly with turns out to be the respondent or the victim. But just because they know them, it needn't be that the judgment of such an IC member would be clouded or they could be partial. Because the basic premise in which an IC member is appointed and trained is that they have to be impartial and unbiased. However, the only exception in this is if they themselves feel that their proximity with the respondent or the victim may cloud their own judgment, then they must step down and recuse themselves from handling this particular case.
What if the complainant or the respondent themselves are a member of the internal committee? In such a case, what must be done?
Now here, Sushmita, there would be a conflict of interest. I'd like to educate our listeners about one of the principles of natural justice, which is nemo debet esse judex in propria causa. The meaning of this principle is that one cannot be a judge in his or her own case. Going by this principle, if there is a situation where the victim or the respondent is a member of the internal committee, such member must step down from being a part of the IC and the inquiry proceedings of that particular case. And in his or her stead, the employer must appoint another person as the member of the IC.
Last weekend, my school friends had visited me for lunch. As we were talking, we spoke about the POSH Act and how the government is sending notices to companies to compulsory conduct awareness programs for employees and orientation sessions for the IC. This is indeed a very good step by the government in ensuring compliance with the law in various organizations, don't you think?
Yes, Sushmita, it is definitely very good to see that the government is being strict in ensuring that organizations are abiding by the law. This will definitely increase awareness of the law amongst the working class and help in building respectful and happier workplaces.
Thank you, Kaveri, for this wonderful session. Ladies and gentlemen, I hope you found this episode very informative and interesting. Do get in touch with us with your queries, suggestions, and feedback by emailing us at admin@upseedconsulting.com or writing to us on LinkedIn, Twitter, Instagram, or Facebook. We will be back again with another interesting topic. Wishing you all a great day ahead.